Good afternoon, everyone. Thank you for coming today. We're so happy that we have so many people gathered to talk about legal licensing reform. It's a topic that I have to say I was excited to see the traction we got and the attention we got around this white paper that our working group did on The World Needs More Lawyers, which I also love because it's just such a provocative title. I believe St. Thomas More in his Utopia said there would be no lawyers, and I suppose maybe that would be true if men were angels. But in any event, we need lawyers. I think we give great value to society, but I also think the world needs more of them. So with that being said, I would like to introduce today's keynote speaker, Clark Neily, who I've known for a long time now, and actually when I was in law school I had him come talk to our Federalist Society chapter there, so not my first time doing an introduction for Clark. He was at the Institute for Justice, as I'm sure many of you know, for a long time. He was the director of IJ's Center for Judicial Engagement. Today, he's the Vice President of Legal Studies at the Cato Institute, where he gets to focus a little bit more on overcriminalization issues and all of that, but he's overseeing their whole program in legal studies. And in addition to that, I understand he's an adjunct professor these days at George Mason Scalia Law School. He was also the chair of this working group, the state and local working group for the RTP, before I assumed that role. And so I am very excited, and I think it's just very apropos that Clark is going to talk to us today about legal licensing reform, and he's just been so engaged on occupational licensing issues in general over the many years. He's always an impassioned speaker, so I'm just delighted that Clark will be here. And with that, why don't you give us a few words, Clark?
Thank you, Luke. It's a bit of a homecoming to come back after a couple of years of being away from the group, and it's really great to be back. And I'm excited about the topic. You know, it is a provocative title, the idea that the world needs more lawyers, and it reminds me of a lawyer joke. And I was thinking, are we really going to do a whole event without any lawyer jokes? And I decided, you know, even though you're not supposed to tell a joke when you're a public speaker, I decided not on my watch. So you're going to get a lawyer joke. But it's relevant because it has to do with the number of lawyers in the world. All right, so here's the joke. Did you hear that they are now using lawyers instead of rats for laboratory experiments? There are 3 reasons for this. First, some people actually like rats. Second, there are more lawyers than rats. And third, there are some things that a rat just won't do. And it sounds like a joke, but it's not. And think about a kind of a basic given, a universal truth of human nature. There will always be conflict. There will always be disputes. And as long as you have government, there will always be overregulation and arguably overcriminalization as well. And so there will always be a need to decide disagreements among people, decide disagreements between individuals and government. And there are only so many ways to do that. And doing it through a legal process evokes the famous saying about democracy, which is that maybe it's the worst except for all other alternatives. The other alternatives are ugly. The other alternatives tend to involve things like overt physical violence or taking your case to some self-appointed village strongman who may or may not decide on a neutral basis. And lawyers, at least ideally, help to facilitate the peaceful resolution of these inevitable conflicts. Now, nobody in this room and nobody in the country knows the correct number of lawyers. There probably isn't a correct number of lawyers, but there are better and worse regulatory environments, and we want to avoid the extremes of either excessive barriers to entry into that profession or excessive regulations on who can provide legal or quasi-legal services so that we have too much unmet need, or an insufficient amount of oversight, on the other hand, that opens the door potentially for exploitation and the provision of services by people who are either not qualified or not capable of providing the service that they're offering. My sense is that virtually everybody in this room would agree that on that spectrum, we're way too far towards the overregulation side. That's certainly my view. I get the sense that that's most people's view as well. I'm not really here to litigate that, if I could use that term, but I will share a couple of personal experiences that make this sort of especially poignant for me and I suspect for many of you as well. I started off at a big law firm, as some of you know, pretty quickly determined that that was not the career path that I wanted, but I did want to pay off my law school loans, so I made sure I stuck around long enough to do that. I then quit, backpacked around the world for 9 months, sort of reflecting on what do I, what kind of career do I want? And what I realized was that I wanted a career that was more fulfilling than the one that I had. A career where it actually seemed like it might make a difference when I woke up in the morning, whether I went to the firm that I actually worked for or I went to the firm that my firm was currently adverse to in some litigation, and you could just do that without missing a beat, because if it's a giant insurance company against some giant company, who really cares which side you're on? That's not the career I think that most people aspire to, certainly not most people in this room. You want a sense of fulfillment. And many of us found that by working for nonprofit legal organizations that provide legal representation to people for free. We help them solve some problem that they have, usually a dispute with the government, in a setting in which that legal dispute would otherwise, or at least they would otherwise not make a serious fight if they didn't have pro bono counsel, because they're not going to go out and hire somebody. They don't have the money. The case isn't attractive enough to retain a lawyer on a contingent fee, for example, and so they're just going to go without an advocate. There's something deeply fulfilling about that, but there's a dark side to that work as well, and again, many of you in this room know exactly what I'm talking about, which is when you get that phone call from somebody who clearly has a desperate and unmet legal need, and their basic syllogism is, hey, I have a legal problem, and you do free legal work, so that's got to be a perfect match. And you respond by saying, well, my organization only works on certain issues and blah, blah, blah. And I kid you not, I have a vivid recollection of a phone call where somebody had a family law issue, was going through an ugly divorce, and I think he was fighting to maintain at least some custody or visitation of his kids. And what stands out about it for me is how ready he was to volley at the net when I made the point that we just do property rights, economic liberty, free speech, and school choice at the Institute for Justice. And he's like, well, it is an economic liberty issue because and then he had this whole argument about like his ability to work and this, that, and the other thing. And it was, it was well played, but I'm sure you know where this is going. I had to tell him, no, my heart goes out to you, but this is just not something that we can help you with. And I think one of the things that haunts me, and again, I suspect many of you the most, is when you tell somebody, the most that I can say to you is you clearly do have an unmet legal need. I am not in a position to help you with that. I'm not even admitted to practice in the jurisdiction that you're calling me from, so I could actually get into trouble. Neither do I have the expertise to help you with this, but you do need a lawyer. And then there's that point in the conversation where you make that sort of half-hearted offer to help them find somebody, which is not going to come to anything, first of all, because you don't really know anybody who does that kind of work in that state, although maybe you could find somebody if you really worked at it. But more importantly, they don't have the money to hire that person. They're not going to be represented. You know it, and they know it. That's a hard conversation to have. It's a really hard conversation to have because, you signed up for this work to help people who have these unmet needs, and you're not going to be able to help this person, and you also know that no one else is going to help them either. And that is, I think, in part due to the over-regulation, the over-restriction of who can provide legal services in this country. There is a hell of a lot of unmet need. I think it was it Lucian who said it was 92% is at least one credible estimate. And it's important to understand what these cases entail. I mean, these cases tend to be relatively lower dollar cases. They involve things like consumer finance disputes, disputes over the provision of services like repair services. I literally just had a neighbor come by my house. I live in an interesting part of North Arlington where the front of my house is what you would think of with North Arlington, but the back of the house is a historically black neighborhood. And there used to be a wall around that neighborhood, and that wall used to go through my front yard. And so my house straddles this very interesting sort of demographic zone that you don't see much of in Arlington anymore. And so this is one of the neighbors from in back. And she said, oh, someone just mentioned to me that you're a lawyer. And it was just almost a replay of the story I just told. You know, she had this sense that you're a lawyer, so you're going to be able to help me. And it was this really convoluted issue about some flood. Her house had gotten flooded. Somebody had said they would fix it. They didn't. The insurance company did something, which I'm not even sure, but I was like, yeah, you definitely need a lawyer. Not me, not my kind of lawyer. But, you know, so I don't have the expertise, and I couldn't have been much help with that. But it would have been, technically, a violation of professional ethics, because I'm not registered, or I'm not licensed in Virginia. I live there. I do a lot of legal work from Virginia. Don't say anything. But not that kind of legal work. And so again, you know, I find myself in the position of having to explain to somebody with a clear unmet legal need that despite the fact that I am in fact a practicing lawyer, I'm just not going to be able to help them with this. And Braden made a point that again is an experience that many of us have had. Many of the people in this room have expertise that puts them probably in the top 0.1% of lawyers in that area. I did some Second Amendment litigation a while ago. As some of you know, there was a time when I probably knew more about the Second Amendment than all but 3 or 4 lawyers in the entire country. I got a call from somebody in Pennsylvania who had a gun-related issue, and I'm like, oh, it wouldn't be ethical for me to advise you on this issue that I am probably one of the 3 or 4 most knowledgeable people in the whole country on. Why? Not because I don't know anything about it, but because I happen not to be licensed in Pennsylvania. It's preposterous. Same thing with those of us who've done occupational licensing, a fairly niche area. The idea that you can't advise somebody who's got an occupational licensing problem in a state where you happen not to be barred is preposterous, and the list goes on and on. And of course, what do you do in that situation, right? Well, I don't know what you do. Actually, I do know what you do. I know what I do, and I'm pretty sure the rest of you have done this too. You know, you kind of obfuscate where you're like, well, it would be unethical for me to give you any legal advice, but I could make some observations about your situation, right? Oh no, you know, and then you send that email letter saying, remember that conversation we had? Well, I am not a lawyer, and it wasn't legal advice. Yes, it was. And that's not, I mean, that kind of, trying to sort of slip the legal advice under the tent, you know, where there'll be no comeback, but you've at least tried to provide somebody with something helpful, I think is unsatisfactory for everyone. I will say, again, I don't know how many of you have had an experience like this. More lawyers than I suspect, you generally don't advertise that you've had this experience if you have, but my former colleague Jay Schweiker and I had written an amicus brief for a criminal case in Alabama. We were submitting the brief to the Alabama Supreme Court. We're not licensed there. We had local counsel that was going to be counsel of record. And this issue came up of whether we could have our names on the brief or not. And some of you have probably encountered that as well. And it became a whole dog and pony show. And to be honest, I don't even remember exactly what the deal was. But let's just say provisionally that we got a letter saying, hey, look, if you want your names to be on the brief, you need to pro hoc. And we looked into it. And it was like several $100s. And it was a whole thing. And we were like, nope, that's fine. Take the names off. And about 3 weeks later, we each got a letter from the Alabama State Bar advising us that they had opened a criminal investigation into the unauthorized practice of law because our names had appeared on these briefs, or we didn't have the right asterisk after our name, or some crap like that. And it was like, I mean, it was scary. It was scary. If you've never received a letter where your name is in bold at the top and the words criminal investigation appear somewhere under there, it's not a comfortable feeling. Now, the good news is it's Alabama, right? So almost inevitably, the partner that we were working with at this law firm actually just happened to be best friends with the lead investigator at the state bar, picked up the phone, said, you're embarrassing me. And then we got another letter saying, oh yeah, that's on us. No, whatever. But there is a sense, I mean, it's funny, right? But that letter was in earnest. I don't think they really wanted to put us in jail, but they certainly wanted to send us a message that Alabama is not for you. Alabama is for Alabama lawyers, right? Even something as simple as an amicus brief. What if we had to try to do an actual representation? By the way, I went down a rabbit hole earlier this morning trying to figure out if my cousin Vinny actually needed a formal pro hoc motion or not. Best I can tell, as long as the judge said it was okay and it was a pro bono representation, he was okay, except for the part where he was doing identity theft. That was probably a separate conversation for him to have with the Alabama State Bar. But as we all know, not only states but also federal courts make it very, very difficult for obviously well-equipped lawyers to represent clients in matters and to provide them with advice and to help them out. Now, maybe some of that is just a reflex, and I'd be willing to stipulate that some of it is, but some of it is absolutely about being anti-competitive and about keeping out foreign lawyers to make sure that only the local lawyers can do that work. And I just think that is obviously, self-evidently, an unworthy motivation for exercising regulatory power. But it does lead to some, actually I was gonna say this. Luke asked me to talk about occupational licensing a bit more generally, and I won't go on about it because half the people in this room now knows at least as much about it as I do, but it's always fun to share some war stories, and there's one in particular that I was gonna share with you in the following context. You have this uncanny experience when you litigate these cases that I would say at least 50% of the occupational cases, occupational licensing cases I worked on, there would come a time during the litigation where either the lawyer for the state or even the executive director of whatever board we were suing, you'd be sitting around a conference table during a break in a deposition or something like that, and they would look at you and say, hey, I was on your website last night. I was looking at some of the other cases that you work on, and you know what? I got to tell you, all those other occupations, it's total crap. They don't need to be licensed. It's ridiculous. I agree with you on all those, but this one, no, this one, right? It doesn't matter if it's florists or interior designers or whatever it is. They absolutely believe that they and they alone, maybe along with doctors. So the anecdote I was going to share with you is that I was at a hearing in the Pennsylvania legislature on a bill to regulate interior designers. There's only 2 states currently, as far as I know. Well, actually, Florida, I think, just repealed it. Is that right, Paul? They repealed it, didn't they? I don't know it either. You need to do a CLE on Florida interior design licensing. Apparently, we should both do that. So anyway, it's not a common thing. And for a while, the interior design industry was really pushing to try to persuade states to license interior designers for the obvious reason. It was 100% anti-competitive. And so, they had these interior designers that were coming in front of these state legislators explaining, why it was so important to license interior designers. And I kid you not, the following story was told by one interior designer. She said, we got that new children's hospital, outside of Pittsburgh, and it's a good thing that there was not licensed, but a certified. This is a private certification. She was trying to emphasize how important it is to have certification or licensure. Was working on that project because they were going to make the neonatal room, they're going to paint the walls yellow. And then this would have been a disaster, see, because some babies are born with jaundice. That is true, my son was, and there's a certain procedure that it's not a big deal, but the thing is, if you're holding that baby in a room with a yellow wall, you won't be able to see that they have jaundice because you won't see the yellow in the whites of their eyes. I kid you not, I told that story to my sister, who happens to actually be a working OBGYN in Maine, and she laughed out loud. She said, that is preposterous. That's not how it's done. But every single legislator in that room was sitting there with their eyes wide open, like, oh my God, I don't want to be the guy that stood in the way of that. Oh no, right? They're so credulous and so easy to convince. But here's the point of the story. In addition to every vocation having a sob story about why they need to be licensed, the other thing that all of those vocations have in common is that if you actually dig into their justifications, they all crumble into dust. None of them have any empirical support. I'm not going to say they're all lies because I think some of them are advanced in good faith, but they are all empirically unsupported and unsupportable. The truth is, and again, I'm sure everybody in this room basically agrees and already knows this, that virtually all of the arguments that are made for occupational licensure do not stand up to scrutiny. There is no empirical support for them. And the idea that lawyer licensing would be the one where all of the arguments in favor of licensing actually do stand up when they don't in other contexts, I think is highly unlikely and bears much more scrutiny than we as a profession have offered or have provided so far. One thing to keep in mind, I alluded to this earlier, is many of us have spent most of our careers working on really big ticket litigation, whether in private practice or public interest, constitutional cases, reviving the Second Amendment, and does it actually mean anything? The Keynote case that I helped work on when I was at IJ, can you take an entire neighborhood of houses for economic development? Those of you who've worked for big firms, multi-billion dollar litigation, a really big deal. Well, guess what? That's not most of legal practice. It's just not. I alluded to this earlier. Most people's legal needs involve things like a couple $1,000s in consumer debt, or maybe a $5,000 or $10,000 repair project on their home. It's not nothing, but it's not millions of dollars. On the criminal side, 80% of arrests are for misdemeanors. And that's not nothing. That's up to a year that somebody's looking at in jail. Most of the sentences aren't. It's usually more like a few months. And there's not enough at stake, I think, to say to somebody, oh, you either have to have this Cadillac-level legal representation or nothing. Again, it doesn't stand up to serious scrutiny. By the way, one reason it doesn't stand up to serious scrutiny? Guess what? How many of you think that everybody who adjudicates legal cases in the United States would obviously have to be a law school graduate, right? Good. No, they don't. Let's start at the very top. Is there any requirement that a Supreme Court justice be a law school graduate? Nope. Do they have to be admitted to any bar to be a Supreme Court justice? Nope. Right? But now go down to the lower levels where most legal action happens in this country. Justice of the peace courts, magistrate courts. I took a quick look online. 32 states allow people to be a justice of the peace or a magistrate judge with no legal training, don't have to go to law school. 17 states allow those judges to sit on eviction cases, which is a pretty big deal. Whether you're going to get to continue to live in your home, that decision can be made by somebody who never spent a day in law school. 7 states allow people to be sentenced to jail by somebody without a law degree. There's appellate review, but there's no de novo review in a trial court by a judge who actually does have a law degree in those 7 states. So it's kind of a tell, right? That you've got a system that's saying how important it is that people have legal training before they provide legal advice or legal representation, but then the matters that are actually being decided in many cases are being decided by adjudicators who have not themselves been to law school. And these are the kinds of inconsistencies and gaps that those of us who've done occupational licensing litigation are so used to. You'll be told that something is incredibly important. You'll point out that there's this big gap. So for example, the florist case that Shoshana alluded to earlier, there was a time actually in Louisiana, actually it still is the law, you have to have a license from the state to be a florist. They made it a lot easier to get, but when I litigated that case, there was actually a practical exam. You had to go and do floral designs for a panel of working florists, and they would judge if you were good enough to be in their profession. The answer was usually no. But then there was an exception to the law that said that you could operate, I forget, I think it was 90 days, maybe it was 6 months, I think it was 90 days, you could operate a florist shop with no state licensed florist on duty if your state licensed florist quit. So I'm deposing one of the board members and I said, I've noticed this 90-day exception where you can keep operating. I said, how come there's no notice requirement? Shouldn't you at least have to tell people that you don't have a state licensed florist on staff? And he's like, oh, that never occurred to us. And I'm like, you think? Really? And I said, could you imagine a hospital that had no board certified surgeons working and they're still doing surgery and they don't tell anybody? And the guy looks at me, I kid you not, he goes, well, I mean, this isn't surgery. And I'm like, yeah, that's the point, it's not surgery. So anyway, and I got to add one more thing on the overregulation point. This idea, that there's a lot at stake about who represents you in a misdemeanor criminal prosecution on the defense side, or the kinds of state administrative proceedings that Braden talked about, or some of these other sort of lower stakes disputes with some government entity that people get drawn into. Guess what? There's another reason there's not that much at stake, because you know why? Because you're gonna lose anyway. You're gonna lose almost certainly. It's not like if you had Clarence Darrow representing you, you were gonna beat that misdemeanor prosecution, right? Maybe you could marginally increase your chances of beating the government, but the game is rigged. And if you've never done state administrative litigation, I did it once. That's all I needed to see. And I'm being a little bit cynical here, but there is some truth to what I'm saying, which is the stakes are not that great because the outcome of the case really almost certainly doesn't turn on the quality of the representation you get. So how much trouble could you really get into with a non-board certified lawyer, or even somebody who didn't go to law school, even if they're a little bit better than you? And guess what? They will be. If they've even done a couple of these things, they're going to be a lot better than you at doing whatever it is, because they just learned the ropes and you didn't have a chance to learn the ropes. That's somebody that you should be able to have on your side. Maybe they shift the odds by a few percent. That looks good to me. How much trouble can you really get into, by the way, that you weren't going to get into if you didn't hire this non-lawyer person? I don't think very much. I'll wrap it up by saying this. Why has our profession been so slow to change, to embrace innovation when other professions have? We spent a lot of time discussing one of those reasons, and it's self-interest. We want to think of ourselves like so many vocations do. Oh, we're a learned profession. You know, I went to law school for 3 years. I had to pass the bar. I wouldn't want somebody who didn't do that providing legal advice. I'm skeptical, as you can tell, of that. There are the ethical concerns, and those are not trivial. We certainly do learn information from our clients that should not be lightly or unnecessarily shared, and I think there is something to the idea that when you train to become a member of a profession, you are more likely to take those kinds of ethical obligations seriously, but I think that's somewhat overblown. And if you don't think so, I refer you to Michael Avenatti. He's a guy in California. And I'm not saying, you know, one example proves the point, but I wouldn't say that lawyers have exactly distinguished themselves through their commitment to legal ethics, even if everybody in this room has, for sure. The last point, though, that I want to make is this. I suspect things would look a lot different and a lot better if we'd been having a more honest and more appropriate dialogue among ourselves. And by that I mean between judges and regulators. When a jurisdiction decides what are going to be the licensing requirements for lawyers, what is going to be the scope of practice, who can do what, can paraprofessionals fill in forms or not, et cetera. When those restrictions are challenged by people like us, by like people in some of the room, or some of the people in this room, those challenges ought to be resolved under some form of heightened scrutiny, intermediate scrutiny or strict scrutiny. Why? I'll give you the short answer. If you want the long answer, go talk to Paul Sherman. Because everything that a lawyer does is speech. We write, we talk, we express opinions. That is all speech. And speech gets heightened scrutiny. And when it's content-based speech, and this is content-based speech because you don't have to have a law degree to talk to somebody about where to park their car before they come up to the firm, but you have to have a law degree to talk to them about their legal issues, it gets strict scrutiny. I don't really care whether it's strict scrutiny or some form of heightened scrutiny because all forms of scrutiny other than rational basis, and that's actually a logical inconsistency, rational basis is not scrutiny. So all forms of genuine scrutiny, which is to say intermediate on up, they get many things right, but two in particular that are most relevant to the discussion we're having today. The first is they get the line drawing question right, which is to say this. So much of litigation with the government involves some form of authorities paradox, which means like there needs to be a line somewhere like, what should the speed limit be? It's got to be more than 10 miles an hour. Or you won't be able to get your kid to the hospital, you know, or you won't be able to get all your errands done in one day, but it shouldn't be 500 miles an hour, whatever. The line needs to be drawn somewhere. One of the most effective strategies that the government has ever embraced, litigation strategies, is ensuring that almost always when there's a line drawing issue, the citizen has to be the one that shows exactly where the line is, and if they can't, then the government wins with wherever it's drawn the line. But when you heighten scrutiny, that tends to get reversed, and the government has to defend the drawing line. The government has to be the one that says, yep, 3 years in law school, that's the minimum. Okay, why? What can't we do in 2? Right? Why can't it be 1? Why couldn't it be an apprenticeship, et cetera? Those are the kind of line drawing problems that tend to be incredibly important in settings like this and that, you know, enable us to move past, professional, historical traditions that have become increasingly untenable in the light of practice and evidence. And when you make the government defend a particular line and say, look, if you can't defend that line, then the person wins, then you tend to get a greater pace of change. And the second point is, and I think this is maybe the most important point, so I'll leave you with this, is the question of demonstrable but unquantifiable costs. There are so many policies that we have in this country that impose demonstrable costs, but they are difficult to quantify. As a libertarian, I hope you'll forgive me if I say, for example, drug prohibition. Drug prohibition imposes massive social costs. Everything from the creation of black markets with all of the attendant violence that exist to preventing people from obtaining their medication, including sometimes their self-medication of choice. I know this because I had a relative who came back from the Iraq War and drank himself to death because he would have preferred to self-medicate with other things that would have been less toxic for his body, but he couldn't because they were illegal, including that scary plant that helps some veterans sleep at night. Massive social costs. But when you're the government in a rational basis case, you don't have to account for those massive, unquantifiable social costs. You don't have to answer for them. whatsoever. But when you have heightened scrutiny, which is what you should have when it comes to lawyer licensing, because it regulates speech, the government does at least have to make some effort to address unquantifiable but very real costs. And in my experience and the experience of my friends in this room who've litigated, anytime you put the government in the position of having to account for anything, they fail. Because generally speaking, they just can't prove what they assert to be true, that people will be worse off if we allow paraprofessionals to represent them in this setting, or that people will be worse off if we allow them to be represented by a non-lawyer in this misdemeanor prosecution where they're only looking at 3 months anyway. When you force the government to not only assert, but defend that proposition, they fail. And if we were having that conversation, which we would be having if courts were applying the correct standard of review, the pace of change in the legal profession would be faster, and the current environment for all of these people whose legal needs continue to go unmet would be better. But since we're not having that conversation yet, although some of us are working on it, we can have this conversation. And so I applaud you all for a wonderful report, and I thank you for the opportunity to be part of this conversation, this important conversation. Thank you.
Thank you, Clark. That was fantastic. And I commend to you, if you haven't seen it, but from the National Lawyers Convention, Clark showed the same intelligence and wit in a debate with with Richard Epstein, who of course is indomitable. We will start our second panel at 1:15 back in the East Ballroom, and so it's 12:51 now. But feel free to continue to talk or use the restroom, and we'll see you back in the East Ballroom. Thank you.